Ladies and gentlemen, apologies for the delay. We'll be starting now. Now, before we start with the conference, I would like to take this opportunity to extend our appreciation to our generous sponsors of the AIAC APAC Pre-Mood. We have our platinum sponsor, Mohanadas Partnership, our silver sponsors, Chong and Keng Ho, Ricky Tan and Co., Sharon Delamore and Co., Vargarb Chambers, and our general sponsors, Cecil Abraham and Partners, Guangxi Just Law Legal Firm, Mahkamaria and Philip Ko, and Halim Hong and Kwek. Not forgetting our sporting organizations, Transnational Dispute Management, TDM Ojimit, China Forum of Financial and Investment Disputes, Guangzhou Arbitration Commission, Careers in Arbitration, Equal Representation in Arbitration Pledge, Africa in the Mood, Asian Law Students Association, ALSA Malaysia, Indian Women in International Arbitration, the United Kingdom and I Malaysian Law Students Association, KPUM. Distinguished guests, ladies and gentlemen, welcome to the AIAC YPG Conference. Thank you all for taking the time out of your busy schedules to join us today. Now, a little intro to the AIAC YPG. Now, the AIAC Young Practitioners Group was established in 2017 under the auspices of the AIAC. The AIAC YPG serves as a dynamic platform for practitioners and students under the age of 40 from around the globe, eager to advance their careers in the ever-evolving field of alternative dispute resolution, or ADR for short. Now, led by our co-chairs, Ms. Lee Kai-jun and Ms. Jasmine Sapienza, they are supported by dedicated members of the core committee and the regional representatives. The AIAC YPG Council is committed to fostering growth and innovation within our community. The current AIAC YPG Council is set to lead the charge from 2024 to 2026. The theme of this year's conference is Vivid Verdicts, Painting the Future of Dispute Resolution. Picture a world where conflicts are not mere clashes of titans, but rather blank canvases yearning for the strokes of masterful resolutionists. Each dispute, a palette of possibilities waiting to bloom into a kaleidoscope of reconciliation. Arbitration is not just a legal labyrinth. It is an exquisite tapestry of finesse and foresight. Vivid Verdicts celebrates this fusion of law and art, where every case is a canvas and every verdict a masterpiece, showcasing the boundless creativity and efficiency of the arbitration process. Now, without further ado, I would like to invite Mr. Lee Kai-jun, our AIAC YPG co-chair, to kickstart the conference. Please put your hands together for Kai-jun.
Dato Professor Sundaraju, Directors of AIAC, Dato Nitin, the keynote speakers of the events, distinguished guests, esteemed colleagues, ladies and gentlemen, good afternoons and welcome to AIAC YPG Conference 2024, titled Vivid Verdicts, Painting the Future of Dispute Resolutions. It is my privilege today to stand before you and inaugurate what promised to be an enlightening and thought-provoking discussions. In a rapidly evolving global landscapes, the traditional dispute resolutions are facing unprecedented challenges in meeting the demands of today's complex disputes. Today, as we gather here, we must confront the pressing questions that define the future of dispute resolutions. How can we harness technology such as AI to streamline processes and enhance efficiencies of dispute resolutions? How do we ensure that the principles of diversities, equities, and inclusivities are woven into the fabrics of dispute resolution mechanisms? And how do we adapt to the shifting dynamics of international commerce and cross-border disputes? Now, the answer to these questions will shape the future landscapes of dispute resolutions. We hope that the discussions today will bring fresh perspective to this and help us to realize the full potentials of ADR. In that spirit, I'm pleased to highlight two panel discussions that will take place today. The first panel discussions will discuss about the use of interim relief measures, and the second panel discussions will focus on the practical aspect of arbitrations proceeding. vis-a-vis the financial or cost aspect of ADR. These panel discussions represent an unique opportunities for us to engage with leading experts, exchange ideas, and collectively shapes the future of dispute resolutions. I encourage each of you to actively participate, ask questions, and share your insight as we work together to navigate the complexities of these ever-evolving fields. Now, thank you once again for joining us today, and I look forward to the enlightening discussions that lies ahead. Thank you.
Thank you, Kai Chun. Before we move on to the keynote address, I noticed that we have our Datuk Sundra Raju here with us today. Datuk Sundra needs no further introduction. He is a chartered arbitrator and a certified international ADR practitioner. And his contributions to the ADR community is truly remarkable. And I think that we young practitioners can learn from his wisdom. Datuk, would you mind coming on stage to address the audience, please?
Sorry, this is most unexpected, because I'm not supposed to give a speech. But nevertheless, Dato' Nitin and colleagues, Kai Jun, thank you so much for coming here today. We have organized the biggest VIS pre-moot in the world, which is quite an achievement, and it came out 1 year ago when I first came into the center in last year. And what we did was we did an alliance with AIAC. I think Alex is not here. I have to thank her. And I was one of the founding members of AIAC. That time we did it online. So when I came back here, then we did a agreement and all these things. But most important today is that it is the Asian century. So it's our century. We have opportunity. But I just want to talk a little bit about the journey. It is going to be my 10th year soon running the center. 2010 to 2018, now 2023 until whatever. But I think the most important thing, I've seen a transformation of ADR arbitration during my time. A number of things happened. In fact, the first thing was branding. Second thing was moving into this amazing building. Then third thing, rebranding again. Fourth thing is that when I came back this time, I set out a blueprint not only for the center, but also for the Malaysia to become a hub in the world. So whether it is carried through or not, it is left to the system. I think one of the most important thing is that whatever happens, AIAC must be an independent and free organization. Independent from the government, independent from interested parties, independent as an international organization. The day we become like China, where all their arbitral commissions are organized by and controlled by government, that's the day we will lose control of the narrative. So actually, for me, the most important thing is that I have done my work as far as possible in the best of my ability. And I only know that history will record what actually happens. So I thank you again very much for this opportunity. It was most unexpected, and I hope that it goes very well. We worked very hard on this, the concept, and more importantly, the execution is my colleagues. They did a great job, and wonderful. And particularly, there was a little bit of a hiccup here and there, but it has gone very well. Thank you so much.
Thank you so much, Dato, and sorry for pulling you without notice. So now to the moment we have all been waiting for. It is our distinct privilege to present to you our esteemed keynote speaker, a luminary whose expertise and insights will illuminate our path forward. Dato Nitin Nadkarni is a consultant and the head of international arbitration at Lee Hishamuddin Allen and Gladhill. He has practiced since 1985 in domestic and international arbitration. Dato' Nitin has acted as counsel or arbitrator in over 300 disputes arising from projects in or arbitrations seated in Malaysia, Singapore, London, Switzerland, Vietnam, Abu Dhabi, Paris, and Algeria. He has been the chairman of the arbitration committee of the Malaysian Bar since 2015 and was a member of the AIAC advisory panel from 2019 to 2023. Dato' Nitin has been continuously ranked in construction disputes and arbitration by various rankers, including Chambers and Partners, Legal 500 Asia Pacific, Asia Law, and Benchmark Litigation Asia Pacific. In July 2021, at the 8th Asian Legal Business Malaysia Law Awards, Dato' Nitin was named Dispute Resolution Lawyer of the Year. In 2022, Asian Legal Business included Dato' Nitin as the only Malaysian lawyer in the ranking of Asia's top 15 litigators. Now, without further ado, please join me in extending a warm welcome to Dato' Nitin Nadkarni.
Good afternoon, good day to everybody, wherever you may be. I'm delighted that so many young practitioners from different countries gathered to participate in the AIAC APAC pre-moot competition and in this conference. I'm very honored to have the opportunity to set the tone for this event. Being a young practitioner myself in the not too distant past, I want to express my thanks, first of all, to Dato' Sundararaju and to the Young Practitioners Group of the AIAC for hosting this conference and for inviting me to deliver this keynote address. This conference is important as it will bring young practitioners together and hopefully equip you with some invaluable knowledge to guide you in navigating your arbitration practice. To go far in international arbitration, one must build strong international relationships and connections with fellow practitioners or arbitral institutions. Being here in person or virtually is the first step for you to form and build those relationships, to understand each other's cultures, as well as the arbitration landscape in different jurisdictions, which is vital in international arbitrations. Unlike most dispute resolution processes, which are firmly rooted in the domestic laws of one country, international arbitration is an evolving transnational jurisdiction. A good example, I guess it's like the Lex Mercatoria that developed in the Middle Ages in Europe to fulfill a gap in dispute resolution and in international commerce. What this means is that the processes and decision-making in international arbitration is not necessarily grounded in any one domestic legal system. Rather, arbitrators are free to consider best practices in international arbitration. The legitimacy of arbitrators in international arbitration is rooted in views developed collectively by the community of nations through such instruments as the New York Convention 1958, UNCITRAL model law, and numerous soft law guidelines, such as the IBA guidelines on taking of evidence and conflicts of interest, the Prague rules, and other such soft law jurisdictions. All of these express a common view as to how arbitration should be conducted to recognize, so as to be recognized as a legitimate and acceptable means of international dispute resolution. And corresponding with this is that international arbitrators perceive that they are not delivering or administering justice on behalf of any particular state, but rather they are playing a dispute resolution role for the benefit of the international community. Accordingly, flexibility and adaptability is all the more important when dealing with cross-border dispute resolution. We need to be open and alert when navigating the differing legal landscapes, other than the one in which we are trained. We must recognize also the value of diverse perspectives. Because of the international nature of international arbitration, there is a major problem which everybody must be aware of, which is different cultural nuances that appear. And the example I like to give is that when you cross-examine an American and you accuse him of lying, he will bang his hand on the table and say, no, I'm not lying, you're the liar. If you say the same thing to a Japanese or an Indonesian, they might look down and quietly say, no, that's not true. You need to understand that the Indonesian or Japanese is just as emphatically denying it, but there are different cultural nuances in the way that some people regard conflict. And that's why arbitral institutions such as the AIAC and conferences such as this are so important, because they help bridge these cultural gaps in the context of international arbitral practice. They are not only a point of contact for international practitioners, but foster relationships and better understandings between each other. Now, the value of arbitrations as a comprehensive dispute resolution solution is enhanced by its increasing ability to grant interim reliefs. I remember a time in the 1980s when if you wanted an injunction, you wanted an interim preservation order, you had to rush to court. You had to get your orders from judges, which kind of defeated the purpose of going to arbitration. In international arbitration, that would be even worse, because you might have different courts in different jurisdictions making different orders that conflicted with each other. For that reason, the development and expansion of interim relief powers of arbitrators, and in particular, emergency arbitrations, is a welcome step. And it's an evolving jurisdiction, and more will be learned. I think one of the speakers in the second session, such relief is rare, it's new. One of the speakers in the second session, I think, did the first disputed emergency arbitration matter in Malaysia about a year ago. So it's a new and evolving jurisdiction. Secondly, the Queen Mary International Arbitration Survey consistently rates costs as one of the major concerns that corporate councils have with arbitration. In the second session, therefore, you will hear speakers talk about something that is of enormous concern to our clients, the management of costs, but which, of course, lawyers tend not to be so concerned about. In fact, the more costs there are, the happier lawyers are. But if we want arbitration to develop, we have to think about this and not just merely about the outcome of the substantive matter. Understanding the rules and good practices behind the topics of interim remedies and cost allocation are therefore critical and in many ways central to navigating and promoting international arbitration. Thank you very much, AIAC and the YPG, for choosing such excellent and important topics of discussion. For obvious reasons, the enforceability and finality of awards is also critical to clients. It's therefore important for us to understand the complexity of enforcing arbitral awards in different jurisdictions and international enforcement mechanisms. What's particularly interesting, for example, is how different countries will interpret the exact same New York Convention. So in Malaysia, for example, if the court of the seat of arbitration sets aside the arbitration, we will not enforce it. In some countries, they will say, we don't care that the court of the seat has set aside the award. We will independently look at this and see whether we want to enforce the matter. And that's an increasing realization that arbitration is international. While it may have a seat, it belongs to the world and not merely to the country of the seat. So grasping and understanding of different jurisdictions and the way that their communities navigate arbitrations is key to working on an arbitration case and developing your international arbitration practice. Finally, I would say use this time while you are still young to get as much exposure and experience as you can. You will thank yourself in the future. Don't be frightened of failure. I can tell you this, in my almost 38 or 39 years in this area, I can hardly remember any cases that I have won. I can remember every single case that I have lost, because I have spent hours trying to understand why I lost in order to improve myself. And I can tell you that I, and most senior practitioners I know will tell you, you learn far more from those cases that you lost than you learn from those cases that you won. Finally, so you should familiarize yourself also with institutional rules such as the AIAC Arbitration Rules 2023. These rules act as a tool to safeguard the arbitration process and streamline the enforcement of awards, particularly within the areas such as interim remedies and cost allocation in arbitration, which are the topics you will hear about in the sessions you'll be having later. Now, remember, legal practice, just as in life, is like a marathon. Enjoy this journey. As I say, don't be frightened of failures. Don't be frightened of setbacks. Now, I wish you all the very best, and I hope you benefit greatly from the 2 sessions in this conference. Also, for those who are here, do take this opportunity to mingle, form relationships, and stay in touch with each other so that an international community of arbitration practitioners can be formed and can foster a dynamic arbitration environment. So now, we also must not forget the importance of honing advocacy skills in this industry, as most of you are here in this competition to do. Finally, I wish all the participants all the very best and hope you have a fulfilling experience. Thank you very much to everyone. I hope this will turn out to be a memorable conference and competition for all of you. Thank you, everyone.
Thank you, Dato. Dato, if I may kindly request that you stay on stage with us for just a moment. Thank you, Dato. That was truly an enlightening and thought-provoking address. We are so grateful to Dato Nitin for joining us today and for imparting this wisdom on us. I would now like to invite our director, Dato Sundra Raju, to come on stage to present our keynote speaker with a small token of appreciation. Thank you, Dato Nitin. Thank you, Dato Sundra. Inspiring and insightful, our keynote speaker has left us with much to ponder as we navigate the intricate landscapes of ADR. Now, let us delve deeper into the discourse with our first session entitled Interim Insight, Debating the Dynamics of Arbitral Measure. Building upon the foundation laid by our esteemed keynote speaker, this session will illuminate critical insights into the evolving dynamics of arbitral measures. The moderator for this session will be Ms. Tatiana Polevchikova. Tatiana is a senior associate at Rybalkin Gorsunyan Dyakin. Her practice extends to international construction, corporate and contractual disputes under arbitration rules of the ICC, LCIA, AIAC, and UNCITRAL. Tatiana has supervised more than 200 arbitration matters and consulted on a wide range of legal issues arising in the course of arbitration, mediation, and statutory adjudication. Further, she was involved in a number of legislative and cross-institutional initiatives. Tatiana is an incoming vice chair of the IPBA Corporate Council Committee and is a committee member of Young THAC. Please give a round of applause for Tatiana.
Good afternoon, everyone. It's a great pleasure for me to be back to the AIAC, where I spent more than 5 years. And I would like to give special thanks to the AIAC, to co-chairs of the Young Practitioners Group, for giving this opportunity to bring everyone together, friends and former colleagues, and to meet the new faces too. And since we're moving to the first panel, titled Interim Insight, Debating the Dynamics of Arbitral Measures, I would like to introduce our speakers. Starting from Ms. Nireen Kaur. Nireen is one of the most outstanding female arbitration practitioners in Malaysia. She is an international arbitrator specializing in building and construction disputes. Nireen is impaneled with the AIC, Thailand Arbitration Center, Maldives International Arbitration Center, and Russian Arbitration Center. She is also a fellow of the Chartered Institute of Arbitrators and the Malaysian Institute of Arbitrators. Nireen obtained her master's in international arbitration with Queen Mary University of London. She regularly appears as counsel at all levels of Malaysian courts. Please give a round of applause to Nireen. Our second speaker is Mr. Hayden Tan. Hayden arrived to Kuala Lumpur just a few hours ago, straight from Singapore. Hayden used to practice in Malaysia, where he handled a variety of briefs, including defamation, commercial law, public law, with a particular focus on business contractual disputes. He was instructed on urgent court applications and has acted in various high-profile commercial disputes involving parties such as airlines, hotels, department stores, software companies, and others. He is currently a legal executive with Kwai Wu and Palmer LLC, pending his application to register as a foreign lawyer in Singapore. He is also an ADR ODR International Accredited Civil Commercial Mediator. Please give a round of applause to Hayden. And last but not least, we also have Dr. Navin Ahuja, who is joining us remotely today from Singapore. Navin is the author of the book, Taming the Gorilla in International Commercial Arbitration, Leveling the Playing Field, and also is the co-president of the Mood Alumni Association. He earned his doctorate focusing on guerrilla tactics in international commercial arbitration. Until 2024, he was in practice development, supporting an international law firm's international arbitration practice in Singapore. Navin is appointed to the Presidential Panel of Arbitrators of the AIADR, an accredited tribunal secretary, an accredited general mediator, and a mediator tutor. He is an editorial board member of the International Arbitration Law Review and has contributed to several publications on the CISG and ADR. He co-coached Vismut teams to winning the best memorandum in the Vis East, receiving honorable mentions in the Vis East and Vis Vienna for the written memorandum and individual oralists, ranking 4th out of 147 teams in the Vis East and advancing to top 16 out of 346 teams in Vis Vienna. We understand that we speak before even younger audience today, so we decided to share some fun facts about ourselves to break the ice and encourage your participation in the discussion. And let me start about a fun fact about Nireen. Nireen loves music from the 80s and have the dance moves to match. Hayden's love of law has no limits. He talks law with his friends, even during casual outings. Navin is a great strategic thinker, not only due to his legal experience, but also due to his passion to snooker. He has been playing snooker for more than 20 years. And wrapping out on our introductions with a fun fact about myself, I was very much into ballroom dancing before I decided to become a lawyer. That's why one of my favorite things these days is to make analogies between different types of dances and different types of interactions the disputing parties may have in arbitration. So without further ado, we can move on, and I would like to invite Navin to introduce us briefly to the idea of interim relief in arbitration. So Navin, the floor is yours. Please tell us, why do we need interim relief and when it can be requested?
Thanks, Tatiana. Pleasure to be here and with honorable colleagues. Just checking if I'm audible. So interim relief, interim measures, also known as provisional measures or conservatory measures, are usually designed for the urgent protection of the rights of the parties after arbitration has been commenced. About the kinds of orders available generally, let's take a look at a few scenarios. One, if relevant evidence might be destroyed, you could apply to the tribunal to grant an order to preserve the evidence. Imagine a shipment of cargo that has arrived, and when you open the cargo, you realize it's wet and damaged. It would be important to carry out a survey and preserve the evidence and identify what actually happened, what caused the damage. Is it related to the ship owner's conduct, or was the cargo defective from the beginning? Because of, let's say it was raining and when loading it became wet and so it became damaged because of when it was in the seller's position, etc. As a buyer or seller of the cargo, you'd want to know the cause of the defect so as to substantiate your claim or defense. If the survey is done 3 months later, there would be low chances in confirming the cause of the defectiveness. A second scenario might be if, for example, the opposing party is using your brand name on their products or infringing your intellectual property rights in any other way. The order might be for an application might be made for a status quo, without which, if they continue using your IP rights until, say, the case is decided, which might take a couple of years, your IP rights might have lost its value. A third scenario could be if there's a high risk of the opposing party dissipating their assets, which is when you could ask for a freezing order. Fourth, a fourth scenario could be if a frivolous claim has been commenced against you and they have no intention of complying with any cause award made against them. You might apply for security for cause. Now, security for cause is an interesting one because while it is generally accepted as an interim measure, it could also be suggested that it is a remedy of its own, given that some arbitration rules provide a separate provision just on security for cause. In the drafting of the 2006 amendment of the UNCITRAL model law, the working group considered the scope of Article 17, which is on interim measures, and concluded that the types of interim measures listed were exhaustive, and security for cause was not on that list. Many arbitration laws, as well as procedural rules, empower the tribunal to grant interim relief. And so, arguably, the tribunal's orders are therefore binding on the parties. Since we're talking about orders, there could also be an order on costs in this context, but I'll stop here. Thank you.
Thank you, Navin. Just one follow-up question very quickly. Since you mentioned that the tribunal makes an order as a result of consideration of the application for interim measures, could you please briefly explain the types of orders the tribunal may grant? Navin, can you hear us? I think there is a problem with connection, but what we wanted to briefly to explain to you is that, of course, the tribunal considers every application for interim measures, and as a result of such consideration, the tribunal may, for instance, fully grant the application or grant it in a certain part or reject the application as such. And Navin also mentioned a very interesting point on the moment when interim measures are being requested, being after commencement of arbitration, which is no longer necessarily the case because the trend is actually different, right, Hayden? So I was just wondering whether you can briefly explain the crossroads between interim measures and the current trend in arbitration towards development of shortened arbitration and emergency arbitration.
This goes to the point that Dr. Nadine earlier has mentioned regarding the emergency arbitration procedure. This is a fairly new procedure which has already been included in AIAC Rules 2023 as well as in SIAC rules. However, this is not commonly utilized at this stage. However, it is a very useful feature because it is, in fact, a hallmark, a testament to the importance of interim measures, how parties were allowed to obtain interim reliefs almost immediately, even before the arbitral tribunal is being constituted. It allows for a very short timeline to be fixed for the arbitration institution to short circuit the procedure of appointing arbitrators. For example, in terms of ICC rules, the president will be able to appoint an emergency arbitrator, short-circuiting the process where parties will nominate the arbitrators and appoint them then. So these emergency arbitrators can immediately spring into action and provide interim reliefs even before the arbitral tribunal is constituted. And after that, the arbitral tribunal will take over.
Yes, and now when we have the general overview about the interim reliefs and the current trend in arbitration, I believe we can just move on to the discussion on certain institutional specificities, because the standards, the power of the tribunal and the standard the tribunal needs to rely on depends on the applicable arbitration rules as well as the law of the state of arbitration. And since we are in Malaysia today, and in particular at the AIAC, I would like to start this discussion with Nireen providing us some details with how interim relief works under the AIAC arbitration rules and whether there are any specificities in Malaysia in that regard.
Thank you so much, Tatiana, for your kind introduction earlier. I also wish to thank the AIAC and the YPG. So just to the question, let's first understand what we are talking about. Interim measures in Malaysia. You have the AIAC rules, you have the 2021 rules, you have the 2023 rules. And what it provides is it gives you an idea of if you are seeking interim measures, this is how you can go about it. These are the types of rule or orders that you can obtain. Now, we have to consider this together with the backdrop of the Malaysian Arbitration Act 2005, which is basically in line with the UNCITRAL model law. What does this help us do? It helps us take steps to obtain such orders. Now, in Malaysia, and this is pursuant to the AIAC rules as well, you can obtain an interim measure, which is basically a temporary measure, to do one of 5 things. First, you maintain or restore the status quo. So when we read or I suppose for those of us who are students and for those of us who are practitioners, when we are faced with the situation, we need to know what it is that we are trying to seek. Are we trying to ask the tribunal to restore the situation, or are we asking them to maintain? The Act provides for both, but we need to be specific. What are we asking for? I suppose in your questions in the next few days, that will be an important consideration, right? Secondly, you can ask the tribunal to give you an order which would either prevent or refrain a party from taking action, which would cause or will likely cause imminent harm. 3, it will preserve assets so that a subsequent award may be satisfied. And 4, preserve evidence. 5, security for cause. That's what my colleague Navin had discussed earlier. So in Malaysia, these are the things that you can seek orders for. But what is important is, okay, so I can get orders for this, but how do I get these orders? What do I have to show to the tribunal? What do I have to prove? You would have to show that harm, it's a bit of a tongue twister, harm not adequately repairable. What does that mean? So there's harm. But this harm is, if it can be compensated with damages, then it may not be so important to the tribunal to give you the orders that you ask for. But if this harm cannot be cured by an order of damages, then it is a valid consideration for the tribunal in granting you your order. The second thing that the arbitral tribunal will look at is that there is a reasonable possibility that the party who's requesting for this interim relief will succeed, means it has merit. So these are the 2 things that we want to consider when we are asking the tribunal for an interim measure, or in your case, when you are perhaps applying to the tribunal to ask for certain measures on behalf of your client. You need to be able to demonstrate these 2 things. I want to just briefly touch on 2 points. In the court system, there is an ex parte order that you can get. You basically one party goes to court and says there's an urgent need for me to get an order to preserve assets. The reason being, if I tell the other party they will go ahead and they will dissipate the assets. Now, under the Malaysian Arbitration Act, by way of the 2018 amendments, 19B and 19C creates this situation. So you don't have to go to the court anymore to ask for an order in the event you're worried that the other party is going to dissipate the assets. What you do is you go to the tribunal and you ask them for a preliminary order. It is one-sided conversation. So you basically apply without the other party, without notice. And what happens is, should the tribunal find in your favor, under 19C, upon giving the order, the preliminary order, they will then go ahead and give notice to the other side to say, by the way, this has been granted by me. Please, for 20 days, it's valid. You now have access to all the papers that were filed and you file your response. What this gives the parties is, in a way, it gives them a forum. I agree to arbitration, and the arbitration forum has all these tools that I can use to obtain interim measures in a preliminary fashion, urgently, in line with what may happen sometimes when we have, for instance, bonds. Well, sometimes bonds not so much, but securities and deposits that are with the other party. You may want urgent orders. So I wanted to highlight that as quite relevant to our Malaysian Act, which is in line with the UNCITRAL model law. Tanya.
Thank you, Noreen. You touched upon a very interesting thing, mentioning that it is presumed that interim measures are temporary in nature. But there is a good saying that's about the temporary nature of things, right? That there is nothing more permanent than something temporary. And in this regard, I mean, I think this phrase kind of also provides an understanding of how interim measures can be permanent at some point. And it also makes me think about the disadvantages the interim measures may have on arbitration. Navin, if you are with us, probably you can provide some comments on the possible arguments against granting interim measures in arbitration.
Hi, Tatiana. I hope I'm audible and visible. Sure. So Naveen was just talking about security of course and dissipation. So that's a good example. Let's say, so claimant has commenced an arbitration, and then respondent might make an application for security for cause on the basis that claimant has no intention on complying with any cause award made against them. So why would respondent make this application in the first place? If claimant is a well-off and say listed company, chances are that respondent will get paid if there was a cost award against claimant. So the presumption here is that claimant is a small-scale company. Claimant will have to pay its lawyers, the arbitrators, and they should not go bankrupt if respondent wins on the cause or the damages. And then claimant would typically raise two arguments depending on the applicable law and rules for the tribunal to not order security for cause. First, claimant could argue that the tribunal has no express or implied power. They could argue that security for cause is neither an interim or provisional measure. Fair to say that it's not the strongest point, as most laws or rules nowadays have expressly empowered the tribunal to order security for cause. And also, even if the tribunal doesn't have the authority, chances are that the court at the seat of the arbitration will be able to grant such relief. Second, even if the tribunal has the power, the claimant could argue that the tribunal should not grant such relief for a number of reasons. One, there is no irreparable harm, perhaps because there's no insignificant change in claimant's financial position since claimant and respondent entered into a contract, or perhaps damages would be an adequate alternative remedy. Two, respondent could argue that respondent has failed to demonstrate that the harm caused to them, if the measure is not ordered, outweighs the harm caused to claimant if measure is ordered. Of course, this is a little bit tricky because you can't say on the one hand that you're able to pay off the costs if you're ordered, but at the same time, you're saying that your financial balance is so sensitive that if there was a cost, security for cost audit now, it would affect your business and there would be serious harm. So that's something to think about. The third point claimant could argue is that respondent has no reasonable possibility in succeeding on the merits. In the context of other interim relief, some points could be argued, such as there's no immediate or urgent need for interim relief. And that's the primary reason for having interim relief in the first place. It could also be argued that there are adequate alternative remedies, such as providing an undertaking. And again, the balance of convenience test to demonstrate that there's more harm in ordering interim relief than not ordering. Thanks.
Thank you, Nevin. Just to add up something to this discussion on objections against interim measures, it's quite often that tribunal also takes into account the issue of possible delays. As you are already aware, the arbitration is being structured at very early stages of arbitration. It starts with the procedure order number 1, which outlines the procedure from the very beginning until the very end. So in different types of matters, be it a simple dispute or a complex construction matter, tribunals are often quite sensitive towards changing the timeline they already agreed upon with the parties at the very outset of the proceedings. So possible delays are also quite often being, being part of objections prepared by the parties.
Tatiana,
Yes.
just to add 2 points on that. First, from the Singapore's perspective, the International Arbitration Act provides that go back to the point of security for cost, that security for cost will not be given purely because the respondent or the other side is resident outside of Singapore, or that it is incorporated, is controlled from outside of Singapore. And there's also commentators that observes that the general stance in Singapore is that it's one of reluctance in granting security for costs. That's the one point which would mitigate the concern that temporary measures feels permanent or being abused by delaying tactics or sabotage tactics. The second point is going back to the emergency arbitration procedures. The interim reliefs that is being given by emergency arbitrator in those cases will be able to be varied or terminated once a proper arbitral tribunal is in place. So that will also mitigate the concern that interim reliefs becomes, in a sense, permanent as well.
Absolutely. Thank you, Hayden. And let's stay with you for a moment. Since we already started discussing the institutional specificities, would you like to tell us about the interim relief under the ICC arbitration rules and how it works together with the Singapore International Arbitration Act?
The framework of interim reliefs under the ICC rules bears a large similarities with what was already highlighted by my colleague Nareen in terms of AIAC rules, except that the wording in ICC rules is a bit wider. For just to take a comparison, in Singapore Arbitration Act, International Arbitration Act, it listed down a list of interim reliefs that the tribunal and the court can give, which includes security for costs, which has been discussed earlier, preservation order, calling of evidence, as well as interim injunction for international arbitration in Singapore. Whereas in ICC rules, the wording is much wider and it reads any interim or conservatory measure as it deems appropriate. So it is a significantly wider parameters for the arbitral tribunal to work around. And in the context of a relationship with International Arbitration Act in Singapore, the court will assist the arbitral tribunal in giving interim reliefs. However, the court will only intervene when the tribunal is not in a position to act. So the interaction between ICC rules and the International Arbitration Act is that at first instance, the ICC rules provide enough bandwidth for the tribunal to work around with. And if the tribunal is unable to act or there is an impasse as to the legitimacy of the constitution of tribunal, then the aggrieved party can go to the court to ask for the relief from court instead.
This is quite interesting, an interesting remark. That means that it's quite straightforward I mean, the process of obtaining an interim relief is quite straightforward in Singapore. In this sense, you are lucky because there is no kind of misunderstanding between who should go to the tribunal and when, and whether it's possible to go straight to the court before asking the tribunal to consider the application for interim relief.
I suppose that also goes into the strategic consideration as well, because although you can get interim reliefs from the tribunal, you need to think about the more coercive force that is perceived from a court order rather than coming out from a tribunal. A tribunal will not have the power of the court, especially the committal proceedings, which packs the most bite in the court order.
Yes, makes perfect sense. And since you already touched upon strategic considerations, let's go back to Nireen. So Nireen, could you please share your thoughts on strategic considerations when it comes to requesting the tribunal to order interim measures?
So I think the first thing that we need to consider, and I think this applies across the board, is what is it that you ultimately want when you have a claim? Are you looking for particular funds? And if you are looking for particular funds that are being held by the other party, then you need to have in your mind, okay, how do I secure those funds now, when the arbitration could take 1 to 2 years? Now, that is something that is relevant when you're thinking about strategy in your case. To help and to aid with that strategy are the tools that are available to obtain an interim order, and the levels that you need to show the arbitrator in order to obtain such orders. But I pivot a little bit. Another thing that is important as far as the practical realities is, as a practitioner, where do you go to make your application? Do I apply to the arbitrator for an interim measure, or do I go to court? Now, as Hayden very correctly said, the court, maybe the impression and the reality is there's a bit more bite, or rather when there is a bite, it's a bit more painful because, you know, they have that whole enforcement ability behind it. So now this issue is relevant because let's say you go ahead and you apply to court. The objection that will come straight away is you should have applied to the arbitrator first. You chose to go by way of an arbitration agreement. So your first port of call should be the arbitrator. Now, relevant to this discussion is a recent case, 2023, MRCB Berhad and Desaru Peace Holdings. Now, the issue before is a High Court decision. The issue before the court there was an application had been made to the court for an interim measure. It was a security for cost. But before that, the party seeking to make that application wrote to the other side and said, do you have any objection if we go before the tribunal? And the other party did not say yes or no. The other party just sort of, you know, gave a very neutral answer. And taking that, plaintiff applied to court for security for cost. Objection was raised by the defendant, and the defendant's argument was you should have gone through the tribunal. Now, this matter went before High Court Judge Yang Arif Ong Chee Kwan. And I just want to, I'm not going to read from the case, although I highlighted it, but quite excited about it. But let me just briefly tell you what the court thought about and considered. The first thing the court said is, if you look at section 19, and if you look at section 11, which does it provide that you have to go to one as opposed to the other? For instance, do you have to go to the tribunal first? Does it say that in the act, or do you go, or are you allowed to go to court? And what the judge said is that there is a concurrent jurisdiction between the High Court and the arbitral tribunal. Now, while that may be the case, we have in mind the UNCITRAL model law. which says that the courts will give due deference to the arbitral tribunal. And if the arbitral tribunal is able to decide on a matter, that it by right should go before the arbitral tribunal. Now, the judge went on to examine a few cases that are relevant. I don't think I'll go into it, but the judgment is very interesting. And I think it's a good read as well. But the one thing the judge said is, even though they are concurrent jurisdictions, the importance of the court is to assist the tribunal if need be. But in this case, there was no reason why the application could not go before the tribunal. And what the judge did was he ordered that all the papers for the security for cause go before the tribunal. And he dismissed the application. But he did cater for 4 scenarios where the court may be the better forum for an interim measure. I'll talk about that a little bit later, but those are the practical realities from a practitioner's perspective. Where do I go to? Do I apply to court or do I apply to arbitration? We must remember why it's important. If you apply to court and the tribunal and the court tells you you should have gone back to the tribunal, who's paying for that cost? Client is going to have to, but you're going to have to answer to him. So that's my view.
Yes, just one short remark from my side on strategic considerations. Interim measures, they're always urgent. And in order to satisfy the expectations of the clients, you have to be ready to not only draft all the necessary applications and objections, but also to be able to advise the client on the likelihood of success of the application. And in order to do that, you must be on top of what's going on in arbitrations under certain arbitration rules. For instance, from what I remember, the LCIA and HKIC, they do provide the statistics when it comes to the successful applications on interim measures under the LCIA and HKIC arbitration rules. I'm not sure if there is, a comparable provision in the AIAC's annual report. Probably there will be in the next annual report, but it's also very useful. So for instance, I believe not that long ago, we had to check the likelihood of granting an interim measures application under the LCA arbitration rules. And the statistics looked for 2022, they were quite optimistic. So a large number of applications are being granted under the LCIA arbitration rules. And Nireen, you also started speaking about the costs associated with the application to grant interim measures. So let's briefly discuss on whether the costs resulting from such applications are recoverable and what is the standard for such costs to be recoverable.
So insofar as cost, the AIAC arbitration rules 2023 has provisions in the event an interim measure is ordered and later on found out to be, perhaps it was not appropriate to have been ordered or there was no merits to it, then an order for cost can be made against the party who sought it. I think that is, in theory, cost order can be made. I think the more realistic, the more relevant question is, what can I do with that? Will I be able to get that money from the other party or not? Now, if you're in arbitration, if an order for cost eventually makes its way to the final award, you can enforce it. And from there, you will basically go about, if the other party refuses, to take all the steps to realize it as if it's a judgment of court. I think the more difficult part is what happens if you have an order of cost and the other party is refusing to pay. I think that is where the arbitrator is very important. How he conducts and how he tells the parties, look, as a matter of fact, you need to make these payments by a certain date, and he has to follow through with that. As Hayden said, you don't have that force of the courts, but an experienced arbitrator, a firm arbitrator, will be able to put parties in their place insofar as an award of cost that has already been ordered. And it's just about respecting the decision of the arbitrator.
Hayden, do you have something to add on the matter of costs?
Just a short one. It's just that under most of the rules, the arbitral tribunal has power to make decisions about cost at any stage of the arbitral proceeding. But in practice, in the majority of cases, you would only likely to expect a cost order in the final award. So that's just something to bear in mind.
Agreed. All right. So Navin, if you're with us, probably you can also provide your thoughts on whether an application for interim measures can be also used as part of dilatory tactics by the parties. Since you're an expert on this matter.
Thanks, Satyana. I think, so I'm assuming I can be heard. I'm audible and visible again. On the costs, it's a little bit complicated because it's not really clear as to in some rules or laws as to when or the reason for costs being ordered in the first place. That's one of the factors that could actually possibly motivate or encourage parties to deploy guerrilla tactics in the first place, because the perception may be that there aren't any actual sanctions, or they don't get punished for misbehavior. Generally, you think about adverse inferences, costs, and a few other things that are expressly provided, but then you're not, the inherent powers are not really clear as to what extent it exists, or the scope of the inherent powers. And normally what happens is, if the cost comes in after the harm is done, and already it might be too late sometimes.
Thank you, Navin. In any case, if any of you has any questions on dilatory tactics or guerrilla tactics in arbitration, Navin is #1 expert to go, and you can, I believe, purchase his book online. All right, so let's move on and discuss one more issue in relation to interim measures. It may become quite an interesting saga when it comes to cases where third parties are also involved. And Nireen, maybe you can share your thoughts on how the involvement of third parties may affect this situation.
Thank you so much. So as we know, third parties are not subject to the arbitration agreement, but the way arbitration is developing, and I think has developed, is that the larger the dispute, sometimes there are parties who get caught up in the fight over the assets. Now, how does the arbitrator decide on or grant an interim measure if the third party is not party to the arbitration agreement? Even if he gives an award or gives an order, it will have no effect, because the third party is not a party to the arbitration agreement. Now, then we look at what I said earlier. The case of MRCB had highlighted a position that has already been established a while ago, that there are some occasions when you need to go to court. And there are 4 situations that were highlighted in the previous authorities. Now, what I think is important is, the first is where it involves third parties. 2, where there's no arbitrator involved. This, of course, is subject to what my colleague said about emergency arbitrators, so that may not be relevant. Where the matter is very urgent, and where the coercive powers of court are required. Now we go into third parties. There, I think it's relevant for me to mention the case of Pada Gurtaj Singh and Axiata Group. Now, it's also a case by Justice Ong Chee Kwan. I'm not picking on him, really. I quite like this decision as well. So let me just perhaps tell you a little bit about this case, because I think it's relevant. The facts are quite complicated, so we're not going to go into that too much. It's 421, so we're just going to make it brief and easy to understand. Party A and Party B are in arbitration. There is a third party who has particular shares. Let's call that party Party C. Party C is not at all involved in the arbitration agreement, but the outcome of the arbitration agreement will touch on the shares that are being held by Party C. what happened was the plaintiff A applied to the High Court. And what the plaintiff did was quite interesting. They applied under Section 11, which in Malaysia is the application, the section you go under for orders to the High Court. So not Section 19, all right? They went under Section 11 as well as Section 19J. Now, please bear with me because I think it's a little relevant. Section 19J provides sorry. It basically says any party, all right? Now, wait. Under 19J, and I think this is relevant, the High Court has the power to issue an interim measure in relation to an arbitration proceeding. We see the language here. It doesn't say in respect of the arbitration agreement between A and B. It's wider. It says in relation to arbitration proceedings. So the plaintiff applied to the court to say, can we get an interim measure under 19J so that the securities, the shares will be held intact pending the determination of the arbitration agreement. And one of the things that was raised by the other party was, look, this is actually relating to a party who is the issue that is before the arbitral tribunal. You shouldn't, any decision that you make here, any order given by court would have an impact on how the arbitral tribunal will later on decide. And in any event, it relates to a third party. There's already an undertaking not to disrupt or dissipate those shares or affect those shares. But the court was not persuaded. What the court said was, this 19J is a very unique provision. It is there to help or to assist the arbitration. So the court was not saying that it was willing to give the other ancillary orders that were sought, prayers B and C. What the court said is, if you want an order to prevent the company C from dealing with the shares, I will give it to you, so long as it is to assist the arbitration, bearing in mind that the tribunal cannot issue such a decision. Now, what does this tell us? If we talk about the landscape of arbitration, it shows that the landscape of arbitration is moving along with the types of disputes that are coming, that are arising in arbitration. So it doesn't mean that, oh, just because if you were a party and you were advising a client, you look at a dispute which has multi-parties and some of them are not before the tribunal, and assets are not before the tribunal, would you then say, let's go to court? Now you can actually advise your client that if you go to arbitration, we can still try to secure an interim order using 19J and wait till the arbitrator has considered the issue fully without having to worry that at the end of the arbitration procedure, you have no assets to basically use as your part of your claim. So I think that was a very interesting case. I'm not too sure whether it's an appeal or not, but I think it was an interesting case that basically highlighted that it's so critical that the laws and the rules evolve with the landscape that we now see, the direction of the disputes.
Absolutely. And having Yes, absolutely. And having a third party involved or a number of third parties involved in applications on interim measures is always very entertaining. Just recently, we had to deal with a number of applications in relation to third parties in one of the arbitration matters. And even though the tribunal rejected one of the applications, the opposing side was very much unhappy about it. And since the appeal mechanism is not in existence as such, what the opposing counsel was trying to do is to submit a further application with more detail providing for the tribunal to, in fact, reconsider its earlier order. We are currently waiting for the developments, actually, so let's see how it goes. But yes, it's very entertaining.
Just to add one point to that, when third parties is involved, arbitral tribunal will have little else to do because the jurisdiction of arbitral tribunal basically is derived from consent of the party, which is the arbitration agreement. And if the third party is not a party to the arbitration agreement, then the arbitral tribunal will have very little that he can do with him. So Nareen has rightly highlighted that the appropriate way then is to go to the court. And in fact, this is not something new, the involvement of third parties. The England's High Court in 2011, in the case of BNP Paribas against Open Joint Stock Company, has in fact granted an anti-suit injunction against a third party, not a party to the arbitration or the arbitration agreement, on the basis that the third party has colluded with one party of the arbitration to start a proceeding in Russia in breach of the arbitration agreement. So that's the way forward. You go to the court and get the appropriate order.
Thank you, thank you, Hayden. And do we have any questions from the audience?
Actually, can I just add? But I was just wondering, rather than going straight to the court, and if the court sees that there's an arbitration agreement involved in the first place, and sending them back and saying, why don't you go commence an arbitration or go back to the tribunal, I wonder what if they actually sought an order from the tribunal and then went to the court to convert it into an order, a court judgment or court order?
In fact, that would have the added advantage because it is enforceable under the New York Convention. So you can go around the world and try to enforce it rather than confining yourself to just one jurisdiction.
Yeah, I agree with you there, Navin. That would have been a more straightforward way about, but perhaps I wasn't counsel for the matter, but perhaps two reasons could have been for that. The first is, I think with the neutral position, perhaps the party who applied to court was not sure whether the party who was neutral was agreeable in the first place to have the application heard before the arbitrator. That could be one of the reasons, and then it just sort of flowed from there. You know, they assumed maybe that there was objection, and that's why they applied to the courts. I assume.
We can further complicate the question. We won't discuss it just now, but just to give you an idea of what else can happen in relation to interim measures. You can have an arbitral proceedings and then, or even multiple arbitral proceedings in different jurisdictions between the same parties. And they can also be complemented by litigation somewhere else. So how interim measures granted in course of one of the arbitral proceedings may affect the litigation, the ongoing litigation. And it's especially interesting when it comes to the document production stage. Yeah, I won't say any further, just not to delay the session, but I believe we still have a few minutes. If we don't have any questions from the audience, I think we can briefly touch upon on enforcement, just a couple of sentences on how. Probably if you have any comments on how interim measures are being enforced in Singapore, just very briefly in Malaysia, and Navin, if you're still with us in Hong Kong, just in 2 sentences.
In 2 sentences, I guess the point I want to highlight is that the Singapore court is again generally known to be very pro arbitration, and there's a recent case CXG where the court held that the international court held that the issue of foreign non-convenience, which will not be an impediment for the court to grant enforcement to an arbitral award. I suppose that shows how the court's approach in Singapore.
A few sentences. So in Malaysia, if you want to set aside, so earlier I said preliminary orders, that is not up for enforcement. So preliminary order after 20 days expires. We're talking about interim measures. What if you want to set it aside? Let's say, I mean, enforcement goes pretty much as my colleague said, but if you want to set it aside, you would have to demonstrate that you were not given proper notice, or the award or the interim measure deals with a dispute that was not contemplated by the parties, or it is beyond the scope of the arbitration. Those are, I think, 3 of the more important things that you need to consider. I think what may fall with it is, let's say the interim measure was in respect of a third party, then there you go, you'd be able to set it aside. So that's how you bring it back full circle. That's all for me.
Thank you. Navin, your turn.
Sorry, I'm assuming I'm audible again. I'm just going to say that Hong Kong, like Singapore, is a pro-arbitration jurisdiction, and it's very hard to set that aside. And also, we have an arrangement with China on the reciprocal enforcement of interim measures. I think it was a couple of years ago where we had 84, or HKIC actually had a list of 90 applications. Thanks.
Thank you. Thank you, Navin. And before we conclude, I just want to suggest each of the speakers um, to come up with one key takeaway you would like the audience to take back with them. I can start actually. So interim measures are always urgent, as we discussed, right? So an immediate action is required. It's always, time is always of the essence. So the more you know about the specificities of the proceedings under certain arbitral rules and the law of the seat of arbitration, the more prepared you are, the quicker you are able to react. So once you receive a mandate to represent a party in arbitration, just make sure that you know the procedural issues from inside out so that you can be successful whether you argue for interim measures or against interim measures.
I think for me, it's what I said earlier. We need to understand our case before we even start drafting. What do you ultimately want? So if you're a student and this is the moods weekend or moods week, what is it that you're trying to get for your client? If you're trying to get assets, make sure those assets are secured, are preserved, are maintained, so that at the very least, at the end of the day, when you're making the arguments for your final submissions or whatever it is, those funds are secured. So knowing what your claim is from the outset is of key importance.
I think for me, the point I want to get across is that fully utilize the global nature of arbitration. Know where it hurts for your opponent. Know where their assets are. Know where their central of activities is, and to focus your interim measures effort in those jurisdiction. Hit it where it hurts.
Navin?
I echo the points just raised, but I'll just say, put yourself in the tribunal's shoes. Think about what actually convinces them to actually grant or not grant the order, what they have to take into account, what their powers are. Thank you.
Thank you. Thank you, Navin. Thank you, Noreen. Thank you, Hayden. Thank you very much for making it to the session today. It was a great pleasure to moderate and reconnect with all of you again. And we just want to wish the best of luck to the participants of the AIAC APAC pre-moods, and hopefully it won't be exclusively academic experience for all of you, but you will also establish lifetime friendships as a result of this experience. Thank you very much, and the very best of luck.
Thank you. Thank you to our moderator and speakers for the engaging session. Please stay on the stage for a bit more. I would now like to invite Dato' Sundararaju to present the panel with our token of appreciation. Thank you, Dato'. Thank you all. Ladies and gentlemen, before we proceed with our next session, we invite you to a short coffee break to enjoy some refreshments. Coffee and snacks are available in the pre-function room, which is located just right next to the auditorium. Please take this opportunity to network and recharge before we reconvene. We will resume promptly at 4:45 p.m. That's, I think, in about 10 minutes from now. See you all. Ladies and gentlemen, we'll be starting now. So welcome back to those who are still here. We will now move on to the second session titled Show Me the Money, Best Practices in Cost Allocation and Arbitration. In this session, the panel will dissect the intricate landscape of costs allocation, shedding light on best practices, emerging trends, and pragmatic strategies to ensure fairness and efficiency in the financial aspects of arbitration. Our moderator is none other than Ms. Lillian Wong. Lillian is a partner in one of the largest and oldest law firms in Malaysia, Shern Delamore & Co. Lillian is also a fellow of the Chartered Institute of Arbitrators. She is on the AIAC's panel of arbitrators and mediators and has acted as an arbitrator. Please give a round of applause for Lillian.
Thank you, Sanjay, for the very kind introduction. Now, I would like to introduce the esteemed panel this evening. So our topic is all about money, right? So all you need to remember is money, money, money. We are going to discuss a lot about money and cost allocations in the next 1 hour. Perhaps I will start with Krista first. So Krista Wong, she's a partner in Lee Hishamuddin Allen and Gladhill with an active arbitration practice in the ASEAN region with emphasis on renewable energy, complex infrastructure and engineering projects. She currently sits as a panel arbitrator in the AIAC and the Chinese Arbitration Association Taipei. She's also the director of the CIARP Malaysia branch. Raja Kumar, sitting next to me, he's a partner in Azman Davison & Co. and a certified adjudicator with the AIAC. He specializes in adjudication, building construction, and insurance matter. He is a treasurer of the CIARP Malaysia branch. So best place to talk about cost allocation today. On the screen, for those that are present physically, you see Sarah Seguin. She is a partner in Tenniel Peak, based in Paris. She's trained in both the civil law and common law traditions. She's a triple qualified arbitration practitioner in England and Wales, France and Canada. She's also the co-chair of the LCIA Young International Arbitration Group. Looking at this panel, I already feel that, wow, this must be an expensive panel today since we are talking about cost allocations. But before I start with the first question, I just want to give a disclaimer that the way how I introduce the panels does not represent all their achievement and accolades. Is really a really summarized version. So don't quote me, because if I think I'm going to start introducing them, we only have 5 minutes for the session. So with that, I think I would like to perhaps give some backgrounds about cost allocation and why is it relevant. Cost is a natural consequences in dispute. And here we are in an arbitration environment. When we talk about cost, there are several elements we normally talk about. Arbitrator's costs, your arbitrator's fees, your legal fees, most importantly, counsel's fees, expert fees, if you have expert witnesses, expert report, expert evidences, or you have factual witnesses, if at all. Are there allowances involved? More importantly, or what we don't want to forget, is if it is an institutional arbitration, you would have institution fees as well, administration fees that you will have to consider. And that brings me to the first issues that we want to discuss today with the panel. I know this, the participants, I acknowledge that might be young, but if you are familiar with this Swedish pop group, ABBA, so there's this song titled The Winner Takes It All, followed by the lyrics, the loser has to fall. So with that, my question is that in the arbitration environment, is it always the case where the winner takes it all? Is that a possibility or scenario where sometimes you win some, sometimes you lose some? And how do we deal with it when it comes to cost allocation? Maybe Raja, since a practitioner based in Malaysia with construction background, you want to share a little bit from the is there a standard practice in Malaysia when it comes to cost allocation?
Thank you, Lillian, for the kind introduction. Thank you, AIAC and YPG for inviting us today. To give you a bit of context, cost is one of the main factors when parties are considering whether to go for arbitration or not. Simply put, if it's too expensive, I don't want to go. If it's is it worth my time, effort, expense? How complex is going to be? Now, ordinarily, when you look at costs, it's divided into mainly three broad categories. One is, as Lillian mentioned, is now party costs. Party costs is your lawyer's fees, experts' fees, witness, whatnot. And then you have the institutional cost, whatever it may take to, say, the rooms and such, administrative fees. And then you have the arbitration tribunals, expenses, and fees. Now, to give you context, the one that's largely in dispute is usually the party cost, which usually makes up to about maybe 75 to 80% of the entire cost. Your arbitrators and cost or fees may only be in the region of 15%, and the rest of it being administrative. And to answer Lillian's question, generally, the law is, as far as in these parts of the world, the cost is to follow the event. Basically, the successful party will be able to get reimbursed for all the costs that he has expended for the purposes of the arbitration. Now, there were, of course, in some jurisdictions, something called the American rule. Now, the American rule is a bit more, one would say, a bit of a Solomon, where they encourage everyone to have access to justice. So that's where they in those jurisdictions or in limited instances, each party would bear their own costs. The losing party will take on the cost of the arbitrator's fees and whatnot. But generally, in these in international, at least in modern international arbitration, what would happen is the successful party would be able to get its costs back. But there is a caveat. One, it has to be reasonable cost. So you can't be putting in say expensive. You hire the Harvey Specters of the world and then expect people to pay you that level. Doesn't make sense. Or should it make sense? And one other item that has since become prevailing in international arbitrations is also to look at the circumstances of the case, the relative success or failure of the claimant. I'll give you an example. What happens if I won the claim, but of all the 10 heads of claims I had, I only won 20% of it? Do I get all of my claims back? Now, I'm going to keep it for you to think about it. And as hopefully at the end of this session, you probably have an idea as to what the answer is.
Thanks, Raja. So I think now as it stands, it's still very likely, or no more probable than not, it's the winner takes it all. I mean, if you have not heard of the song, later after that, you can Spotify or Google later. Next, I want to ask Sarah, because Sarah has experience in ad hoc and institutional arbitration. Just for your information, when we talk about ad hoc arbitration, that means it is an arbitration not governed by a specific institution, for example, SIAC, AIAC, HKIAC. So Sarah, what is your take on this? Is there a best practice or is there a standard practice in your jurisdiction?
I think I would have to agree with what Raja said. And I won't quote the song, but to answer your question, does the winner take it all? I think the answer has to be a nuanced yes. And much of the practice in England and in France is focused around the LCIA and the ICC rules. These are institutional examples, and I wanted to maybe just say a few words without repeating what has been said before to give you an idea of how costs are approached. And under both sets of rules, there's a lot of discretion given to the tribunals and how costs are to be allocated. The ICC rules will just say, for instance, that the tribunal is to fix the cost in its final award and decide which of the parties shall bear them and in what proportion, and that's an interesting aspect, they shall be borne by the parties. And so there's, as you will notice, there's no indication in this rule of how the tribunal is to approach cost allocation. In the LCIA rules, by contrast, there is a rebuttable presumption that the successful party may recover such costs, or its costs, from the unsuccessful, I'm going to start again, party. Article 28.4 of the LCIA rule provides, and I quote, that the arbitral tribunal shall make its decision on both the arbitration cost and the legal cost on the general principle that cost should reflect the parties' relative success and failure in the award or arbitration or under different issues, except where it appears to the arbitral tribunal that in the circumstances the application of such a general principle would be inappropriate. And in such circumstances, the arbitral tribunal may also take into account the conduct of the parties or their authorized representative. So that gives you a general idea, but even if the ICC rules do not provide for such a rebuttable presumption, my experience is that the majority of tribunals will broadly adopt as a starting approach, or as a basis at least, the principle that the winner takes it all. And I open here a parenthesis because for many of the practitioners, this has sort of become the starting point when you approach cost allocation, but it doesn't need to be. And Raja referred to this. Another perhaps equally legitimate starting would be that each party will pay its own cost. And in fact, this is what we have been seeing in investment arbitration as opposed to commercial arbitration. While there is a bit of a trend in the recent years for investment arbitration tribunals to begin allocating costs to the parties on the basis of the winner takes it all, historically, really the basis for a proportioning cost in investment arbitration has been described as you pay your own way. So each party has to bear its own cost. So basic principle is the winner takes it all. And to me, that brings the more difficult question is how do you define success? Because it's one thing to say that if you succeed, then you are entitled to recover your cost. But as I think you will find in your own practice, it's very rare that a party will prevail on 100% of its claims. Sometimes a party might prevail on some of its claims. The tribunal might find that some of the counterclaims were valid. And so that brings the question of, in these sort of gray circumstances, how does the tribunal define who truly is the winning party? And in my experience, there are a number of ways to do this. Tribunals can award cost as a proportion to the relative degree of success. Option one is that if the claimant or the respondent succeeds on its core claim, then the tribunal can find that it is entitled to recover all of its reasonable cost. Option two would be a proportioning cost on a claim-by-claim basis or on an issue-by-issue basis. And finally, option three would be a proportioning success against the amount of damages originally claimed or the value of property in dispute. And there is no clear rule or clear defined practice as to which options tribunal go for, in my experience at least.
Thanks, Sarah. Krista, now I come to you. I think Sarah has shared these various options. You have the percentage option. You have the issues by issues options. What's your experience like? And especially, I know that you're a seasoned litigators when it comes to complex projects or renewable energy matters.
Thank you, Lillian, and for the introduction, kind introduction, and also for AIAC YPG for inviting me to this panel. So firstly, I think I need to start by echoing Lillian. This topic itself, it may be mundane when you look at the title itself, or it may be linked to the mood that you're going to do, and that's why we're speaking on this. But in practical sense, this topic is very important for probably 2 to 3 reasons. Starting first with the QM research, right? Primary research already talk about a lot of stakeholders use of arbitration complaining about costs. So what can we do about it in the arbitral community? We can talk about it, we can improve the situation, think about the strategies and considerations that will assist your client. That's point number one. Point number two, so one of the first few questions that client will always ask us, what is the cost of the arbitration? What are the costs of arbitrations that I will be facing if I go for arbitration? So as their solicitors or the people in charge of the case, you will have to quantify it. And when you start off quantifying that with them, you probably think about tribunal fees, administrative fees, legal costs. There are a lot of other costs that you have to factor in: transcription, venues, experts, and so on and so forth. So bear that in mind when you first start off practice and you have to quantify that. Then the next thing that I have to also perhaps share with you is in relation to come to this question. Perhaps Raja is acting as daddy and asking you to think about it, and later on you will come to a conclusion. As a mother myself, I'm probably going to spoon feed you with some real life example. And I do think that that is very important because we always talk about cost below the events, cost in the cost. What do you actually mean by that? So I have a series of 3 energy arbitration in the first 2 years of my practice. And so what we did just now together with Ruth is I basically plowed through my email and I got back the award itself. Go to the deposition section and I'm going to read to you what happened and what real cases, how the tribunal actually decide on costs and the eventualities that we have in actual cases, okay? So starting off first, the first one is a power purchase agreement in relation to liquidated damages. So client is claiming that we're not liable for to pay liquidated damages. So first arbitration itself won 100%. And the outcome would be the respondents, so we're the claimants, respondents to pay all legal fees, legal costs, fee and expenses of the claimants arising from an arbitration, except the fees and expenses of the claimant's expert witness, of which the respondent is only ordered to pay half. And that is because certain findings from the claimant's expert reports that the tribunal don't think that's so helpful. So that's one consideration that we see. The respondents to pay all administrative costs arising from the arbitration, fees, expenses of tribunals, and administrative secretary credits being given to the respondents for all advances on the cost it has paid to the KLRCA at that time. So you know how long it was ago. So that's one way to deal with it, where you really focus on parties' submissions on costs and then decide on the various heads of claims in terms of cost. So heads of costs, okay? So in that situation, the legal cost itself for claimants is 1.8 million, for the respondents is 2.8 million. So you can see the stark difference between the two and why the tribunal easily picked up the figure of the claimants and awarded as it is. Because by comparison, 1.8 to 2.8 million, 1 million difference in terms of legal costs obviously would render the cost of the claimant's legal costs as being very reasonable to understand, to say it. The conclusion would be that since the claimant has succeeded in this instance 100%, and since costs follow the event, the claimant recovers from the respondent the sum. Okay, that's number one, the first arbitration. And when I read the earlier one is actually the second arbitration. The first one 100%, second one 100%. Now come to the third one. Outcome of the case is actually slightly different from the first two, even though it's the same series, or when I say same generation power purchase agreement. Third case, the claimant's successful claim of certain amount is 12.33% of the value of the claimant's total claim. Okay, so Sarah talked about earlier, you can peg it against damages awarded, you can peg it against the amount in dispute, the value of claims, the heads of claims. So there are different ways of doing it. For this particular arbitration, it's pegged against total amount of the value of the claim. However, I mean, there are other considerations that the tribunal take into account. The tribunal come to a point that even though it's 12.22%, 90% of the legal fees is due and payable by the losing party to the winning party. But most importantly, why I choose to share about this case, not just there, the tribunal in this particular proceeding actually went on to scrutinize the issues within the matter. I think later we'll come to interim applications. Within this particular arbitration itself, we talk about preliminary issues, preliminary objections. So the losing part of the application by the parties, also the tribunal also factor in this when they are deciding on the final cost to be payable. Apart from that, when it comes to the quantum of the cost, so we talk about liability, how many percent due and payable. And then when you write your second part of the award, you come to the quantum of the cost, right? So when you have that 90%, 85%, what is the cost? What is dollar and cents that's due and payable? And when the tribunal is dealing with this, tribunal look at the biggest cost. Remember just now, I think Kumar talked about 75%, 80% of the cost is actually the legal cost. And that is truly reflected in this award itself, because the total claim is 3.7 million. Biggest item in this sum is the legal cost, 2.9 million, right? So of course, party A say that this is extravagant, excessive, and do not represent party-to-party costs. And of course, then the tribunal will have to decide whether this is reasonable. And when you decide what is reasonable, what do you look at? In this instance, the tribunal actually went ahead and looked at the breakdown of the legal team, the charge-out rate, hourly rate of these people, the time spent by these people, I mean the legal representative, between the two. So what they notice is actually the biggest difference is between the charge-out rate of 1,000 per hour against the other team of 6,000 an hour. Is that reasonable? Right? So that's one of the factors. And legal team, one team you have 4 to 6 lawyers, another team you have 2 lawyers. Right? Allocation of cost resources wise, does it make sense? So all these are the things that I think we have to factor in when we consider these important issues, especially when you are acting as an arbitrator writing the award itself. I think I need to stop here.
Thanks, Krista. I think both of you have mentioned about this test of reasonableness. That's the beauty of dispute resolution, right? Everything is fluid, it's subjective, it's up to the practitioner here. How are you going to argue? So I think I just really want to draw into a little bit more, especially we have Sarah in a different jurisdiction with us, also to get some of her insights in respect of this test of reasonableness. Sarah?
I actually really agree, and it's interesting that Crystal was able to share with us these awards, because I think they shed light on a really interesting aspect of a consideration that tribunals will take into account when allocating costs, and that's reasonableness. For instance, the ICC rules will provide that the tribunal is to allocate the reasonable legal and other costs. So it's a sort of a presumption built into the rules that the cost you claim have to be reasonable. And even when the rules of the arbitral institution that you apply do not provide for this standard, it's become standard practice for tribunals to require the parties to only claim reasonable cost. Now, the $1 million question, of course, is what is a reasonable cost? And as you've mentioned, of course, there's a subjective element to it. In my experience, one way to approach the reasonableness of the cost claim is to assess whether they are proportionate to the amount in dispute or to the value of the property in dispute, or whether the costs are, generally speaking, proportionate to what is being in dispute. And there are a number of proxy factors that I think tribunals can look at to decide on this factor. Crystal mentioned a lot of them: the reasonableness of the rates and the number and level of fee earners when they evaluate the amount of work that was done, the reasonableness of the level of specialist knowledge that one party decided to hire. For instance, did you really need 25 really senior legal experts on a particular issue of law? The reasonableness of the time spent. Was it necessary for you to send an army of junior lawyers, for instance, on a site visit, for instance? And another factor is going to be any disparity between the cost by the parties. If you have hired yourself an army of Harvey Specters that are really expensive, and the other side has decided to have a lean legal team with fee earners that have much more reasonable hourly fees, it's likely that the tribunal will look at the two and think, well, one party is claiming 5 million in legal cost, and the other party is claiming 500,000. There seems to be a disproportion here. And that might affect the tribunal's consideration of whether or not your costs are reasonable. I don't want to say too much about this at the moment, but I think there are also interesting considerations when we look at what are reasonable costs, such as Are internal costs reasonable? As you can imagine, when we're talking about legal costs, we're not only talking about the fees of the Harvey Specters, but also inevitably the fees of your in-house counsel or your operational team who have to spend a lot of time instructing solicitors following the arbitration. And in my experience, it has become more and more common for parties to want to recover the cost, the time, and the energy that their in-house counsel have to spend in arbitration proceedings. What about third-party funding costs? There have been, let me take a step back. So third-party funding is becoming more and more popular in arbitration, and it's the mechanism whereby a third-party funding firm will come in and will finance a party to go to arbitration with the expectation that if that party is successful, the third-party funder is then able to take its capital on investment, its return on investment, as part of what that party wins. And there are a few cases in which the winning party said, well, wait a second, I had to get third-party funding to prevail in this arbitration and to bring this arbitration forward. I want to claim the cost of these third-party fundings back. Is this reasonable? And a third example could be a success fee. A party that had to hire a lawyer on the basis of a contingency agreement, and that will have to pay his or her lawyer a significant amount of what it earns in the arbitration, of what it wins in the arbitration, might be tempted to say to the arbitral tribunal, I want to claim that back from the other party. So as you can see, reasonable is just not the amount. There can be, I think, an item per item consideration of what are the costs claim and whether each of these items are reasonable.
Speaking from litigation and arbitration background, most of the time I always like to tell people that arbitration or tribunal, they're a lot more generous when it comes to court litigation. But when it comes to arbitration too, that is where you actually will really scrutinize item by item, whether you use senior counsel, you use junior counsel, what are their hourly rates. I once had a matter where the tribunal thinks that it's not necessary to intrude or to adduce any expert evidence, hence refuse the rejected costs for expert evidence and for them to fly over and for them to prepare expert report in that sense. Raja, what's your take on this?
I mean, first off, I have to say this, and the caveat is this: there's nothing wrong in hiring a Harvey Specter. If you have the money for it, go for it. And I think the second part is it may be a bit confusing when one says reasonableness, you somewhat associate that with cost effective. And to cite Sarah's example earlier between one party claiming 6 million, another party claiming 500 or 500,000, it doesn't mean that the party claiming 6 million won't get it. He just has to justify it and see whether or not the cost is inflated for reasons as mentioned by both Sarah and Crystal in terms of, do you really need this many people on the file? If you do, so be it. And there is a reason for this in terms of, like, say, we talk about high level senior partners and the necessity for them. See, what you need to remember is when you're the claimant, you're mounting the claim. So you're pretty much the one setting it up. So a lot more work may go in towards it as opposed to the respondent who's responding to it, assuming that they don't have a counterclaim and such. So under those circumstances, I think it's reasonable to assume that the claimant's cost would necessarily be more. I think that's one of the things that one must look at when you're talking about reasonableness. The other end of the spectrum is if, for example, we're talking about cost for an interim application. I think we went through a few earlier, and one was about security for cost. And part of the security for cost, you will put up your bill and say, listen, this is how much it's going to cost me to go all the way for arbitration, and this is how much it's going to cost the other side. If it seems unnecessarily tilted one way or the other, then at that point, the arbitrator needs to make a determination. Is this fair? Is this reasonable? Should I even go one step further and decide that the respondent should have to bear the cost or high cost for that matter? And speaking about third-party funders, that's one of the issues I think that comes up in the security for cost applications. Because let's just say the claimant is, I mean, to quote a celebrated case, the Sulu case, for example. he doesn't have money of his own. He's got third parties to fund for him. He goes off and he sues the respondent willy-nilly with a claim and then gets stuck with a cost. He can't pay for it. And because the third-party funders are not a party to the agreement, there might be some limitations as to how you can get the cost again. So under those circumstances, maybe you might want to consider the reasonableness of the award of the cost. And those are some of the things where I think you need a Harvey Specter and you should pay a bit more. Yeah.
Okay, see, so now, I think after hearing from the panelists, it just seems that lawyers can really fight on every single thing, down to the hourly rate, and then it might be the number of years of experience, how much you should charge, how many hours your secretary overtimes are, whether Raja is older, more senior, so he's entitled to charge more than myself, things like that. We are fighting, but of course, it's really relevant. So then the question is, of course, if you're the successful party, you want 100% of every single thing down to overtime and coffee when you have to work over the midnight in the office. But what if you're the unsuccessful party? What can you do? How do you then argue and say this is not reasonable, that is not reasonable? Because in the end of the day, it's the discretion of the tribunal to decide. So then what I have been thinking, and in fact, in many arbitration procedures, I think many of my colleagues would appreciate is, are there issues such as penalizing parties for not behaving in such an efficient manner or effective manner in conducting the arbitration proceedings? For example, unnecessary evidence or interim application, prolonged cross-examination. For one short witness, you take 20 days. You know, over drinks or functions, sometimes we hear lawyers say, oh, this is my 89 days of trial. This is my 101 days trial. What are we doing for all this? Sarah, perhaps if you want to share some insights on this?
I think it's an excellent point that you raise. We've now talked about two considerations that tribunals will take into account: the extent to which a party has been successful, the extent to which the cost can be said to be reasonable. And I think a third consideration, even when they start from the basic principle that the winner takes it all, is whether or not a party has contributed to making the arbitration proceedings longer, less efficient, generally unreasonable procedural conduct. In the ICC rules, for instance, there is a specific provision that says that the arbitral tribunal may take into account such circumstances as it considers relevant, including the extent to which each party has conducted the arbitration in an expeditious and cost-effective manner. Relevant examples that you see being argued in practice will include excessive document requests, of course, to the extent that they're not granted by the arbitral tribunal. You've mentioned it, a lengthy cross-examination. It can be overly lengthy legal arguments with legal arguments that are being made that are not directly relevant to the point. Dilatory tactics or guerrilla tactics, exaggerated claims, failure to comply with procedural orders of the tribunal, or an unjustified failure to comply with the procedural timetable that was set by the tribunal. I do think that, generally speaking, however, tribunals want to see arguments being made as to behavior that made the proceedings less efficient. And in my experience, tribunals will be open to sanctioning a party that has genuinely made the arbitration proceedings less efficient. What, in my experience, tribunals do not want to hear at this stage, it's sort of a general airing of grievances. If you're just complaining about procedural conduct that hasn't actually had an impact on the procedural timetable or on the procedural conduct of the arbitration proceedings, that's something that tribunals tend not to want to get involved in. And perhaps on a more practical note, I would say that if either as I sit as an arbitrator or when I act as counsel, I think it's helpful for the parties in the tribunal to discuss the extent to which the procedural conduct of a party will be taken into consideration when allocating the cost at the very outset of the arbitration. So when you have your, say, first procedural case management issue, when you draft up your terms of reference or whatever it is, but I think at the get-go, it's helpful for the parties and the tribunal to set the expectation as to what, when the tribunal will allocate the cost, what procedural conduct, if at all, can be taken into consideration, because the parties might have different expectations. And so I think it's helpful to set them out from the start. And at the same moment, there are many practical questions that I think the parties and the tribunal can address, such as what are the costs that will be recoverable? You know, we've mentioned third-party funding or success fee. Another useful question would be what records will be needed to substantiate the cost? And many other questions, I think, can be aired out at this stage, including, you know, settlement offers, for instance. Is this a consideration that can come into play when you allocate costs? So my practical advice would be discuss it with the tribunal from the get-go so that you have a clear idea of what the expectations from all parties involved will be.
And Krista, you have sat as an arbitrator before. So perhaps you could give us some perspective as an arbitrator. Now you see two sets of cost summations with all these Harvey Specter's arguments and, you know, different rates. So what's the method? Is there any tips on this?
Generally for, I suppose generally for domestic arbitration is more straightforward in the sense that both parties will put in competing or equally convincing submissions, cost submissions. So I think that's not too much of a problem. So you just compare between the two, and in line with, because I have the benefit of the sets of three arbitral awards for me to compare in a like dispute how they actually delivered on this very issue. But for international arbitration, where it involves parties from different jurisdictions, that gets more interesting. So I sat as an arbitrator, sole arbitrator in an expedited proceeding between parties, Singaporean and US. So what happened in that situation is that the US party actually filed cost papers. It's filed in US proceeding in my arbitration and say that that should be adopted as the statement of defense. So obviously I gave chance and say that, like, this is different issues. You may have to file your own, a new set of statement of defense, counterclaim, you know, up to your own strategy. And the respondent refused to do so and chose to adopt the paper filed in US as the statement of defense in the arbitration. So that's not the end of the story. And thereafter, you have situation where the respondents actually failed to follow the procedural order and timeline. So timeline has been extended and perhaps went silent mode for, say, a month. Thereafter, apply and say that, can I still file certain submissions or new documents and all? Obviously, claimants would have to deal with it, right? Then towards the end of the day, my lesson learned from this series of events is that when you intend to ask for adverse costs, that's how I term it, please put in your reservation. So in this instance, the claimants was pretty, of course, the claimants objected to all these requests for extension of time, for late filing, for new evidence. But end of the day, I've decided that for natural justice, and short extension of time is permitted. Let them file it. And so time clocks up for the claimants. And in the cost submissions, you will see that as a result of all this extension of request delay tactics deployed by the respondent, a lot of time would have to be spent to address all this, address their requests, whether it's reasonable or not, put in reservations and justification for all those. So from my perspective, if it's a straightforward matter, the amount is claimed, obviously, to me, by the claimant to resolve these disputes should not be that high. Yeah, loosely I use it. But in view of the respondent's behavior in the expedited arbitration, I actually plow through the hours spent by the team, the claimant's team, and I do deem it as being reasonable, especially with the reservation. So in the cases that I'm handling at the moment, whenever there's interlocutory applications or whenever there's a request by the other side, the first thing we'll write in is to see that if it's a straightforward one-page reply or a few lines, then so be it, right? No, it's fine. But if it's a situation where you need to research and address it properly, when it's a matter of principle should not be raised, then the reservation of cost must be there in your reply. And I have instances where parties failed to submit their cost submission. And what can an arbitrator do? You can remind perhaps, but is it fair for the other side? So that's a big question mark as an arbitrator or adjudicator where you have to decide on this issue. That's something that I can share. I think following from the one of the comments that I think Lillian made was, I think I can share this case that Ruth found. It's a Singapore case of VV and another against W, 2008 SGHC 11. So in paragraph 14, I think this is observation by the arbitrator is pretty helpful in the sense that the arbitrator actually said that the arbitrator also gave a discount to reflect the fact that in his will, it was not reasonable for the defendant solicitor to A, charge for overtime or all overtime at double the normal hourly rate, or for the days spent by the defendant's lawyer out of Singapore to allocate only 5 hours a day to be charged at normal hourly rate with the remaining working hours per considered as overtime. So when we actually submit our cost submissions, we do have to be quite careful in terms of how we scrutinize, are we charging overtime? And if we are, at what rates, how many hours?
Raja?
Sorry, just one short point. I think we've sort of gone through some of the factors to be considered in cost, and this being conduct of parties. And, we talked about the length of your submissions. We talked about, having to put in discovery applications at the very last minute. But one of the things that I find in my experience that often gets overlooked is, in fact, whether or not parties concede to certain claims. And that's a huge consideration because you're making the life of an arbitrator a lot more easier if, based on the evidence, you can concede to some claims which the evidence isn't just on your side, or perhaps not something is one of your strongest points. And those things I find in favor of the tribunal and tends to, and may be considerations to be made when determining cost, because you're talking about conduct of parties. Now, on the flip side of this conduct of parties, we talk about cost, and we talk about how you can sanction parties if they say don't prescribe to procedural timelines. But one must also consider, at the end of the day, your arbitration award may be subject to set aside due to perhaps not giving them the due process. And so, for instance, you denying them the right of, say, documents or the right to apply, or then sanctioning them may be seen as you curbing those rights in the interest of justice, as it were. I mean, leave it to lawyers to come up with some kind of artistic manner to set aside your arbitration award. But it's just something that as arbitrators, we continue to struggle, because you have to keep a balance between these two. And so that's something that's my last point on the conduct of parties. Yeah.
Now, I would like to discuss a little bit more on interim measures, because Krista, you started it by saying that cost allocations in interim applications are also very relevant. You want cost in the cost, you want, or whatever term you use it, cost follow the event. No order as to cost if you are the unsuccessful party, or you want cost when you are successful parties. How do we deal with this?
I think the starting trend of interim measures is always cost follow events or cost in the cost. So you would deal with it perhaps later on, together with the award proper, we call it final award or partial award itself towards the end, right? But one interesting matter that I want to share with everyone is a recent matter, the French arbitration that we did concluded, I think last year itself. These actually is Sarah with your ex-partner, Shapara. So it's in GAR, so we can share a little bit about it. So it's a situation where my client applied for raised preliminary objection in the sense of a jurisdictional challenge. So you have two options in this situation. Either you raise it towards the end, or raise it in your statement of defense, raise it in your response to NOA, tribunal deal with it together with hearing proper, option 1. Option 2, bifurcation. So in the sense that you ask for this matter to be decided way in advance in a partial award before going to the hearing proper if the decision is not in your favor, right? So in this particular matter, we raise it as a jurisdictional challenge in the way of bifurcation. So the tribunal will have to decide the matter or decided to go for it in deliberate on a matter. The surprising thing to me is that in Malaysia, I think the trend is that we deal with it towards the end in terms of cost, how much parties spend for this preliminary objection. And that is same as the earlier case that I mentioned moments ago. For this particular matter, the tribunal actually decided that the losing party should be ordered to pay the cost, and the cost is set at amount of 100,000 euros. And of course, for I think under French law, I will let Sarah address this and enlighten us about this, is that if it's a partial award and you want to annul the partial award, this part of the claim would have to be settled before you can proceed further in terms of annulment application. So that actually has an impact on what's party next step, and it would impact our cash flow as well. Addressing the cost part of this, the application in terms of interim and the bifurcated part of it. Yeah.
Sarah, since Krista has started about this French case, perhaps you would like to add on from that?
Sure, I can say a few words. I will say I wasn't actually working with Crystal on that case. I would very much have liked to. But so what I can say is more in terms of general contribution. And I think Crystal raised actually two excellent and really on point points that parties often forget when they think about interim applications. In my practice, it's more common for arbitral tribunals to wait until the end of the arbitration, or at least the end of a phase of the arbitration, to allocate the cost. So at least until the end of a bifurcated phase, for instance, or until the end of the arbitration proceedings. And the reason for this is that tribunals do feel that they're in a better position then to sort of take a general view of which party prevailed on which arguments, so which party can be said to be, say, the winner, and also which party, which arguments as to procedural conduct can be taken into account. It is, however, more and more frequent to see parties ask for interim cost award, really as a way, I think, to sanction a party that is acting unreasonably in the arbitration. And two things that I think Crystal alluded to, which are extremely important when parties request these awards and don't necessarily think about it, is that if the tribunal is to make a determination on costs in the form of an order rather than an award, or an interim order, which is of course entirely permissible, this order or this interim award may not be enforceable under the New York Convention unless and until it is incorporated into in a final award. So you might have this decision from the tribunal, but query as to what practical advantage it will bring to you and to your client. And the second, I think, really important consideration is that making a decision on cost at an interim stage can really alter the dynamic of the proceedings. Because once the costs are paid, it may not be possible to recover them later, once they become definitive and for the final stage in respect of which they are ordered. So the interim cost award may have an unintended impact on the financial cash flow of the parties being made to pay it. And I think these are important practical considerations that parties do not sufficiently think of before asking the tribunal for interim cost awards or decisions.
Before I want to move on to the next issue, this interim cost, I think I just really want to emphasize what Sarah said when she started. Sometimes people do forget, especially if you've got a very lengthy arbitration matters with tons of interim applications. And suddenly when you have to do a cost submission, you'll be realized, oh, actually, how many have I done it? Then you have to take out all your matters. So a tip for all the junior associates, don't forget all your interim applications costs when you have to do it at the end. Okay, now, I think for the first half an hour, we have heard a lot about costs, fights, how do you argue if you are the successful party, you want everything, and you are the non-successful party, you're trying to minimize it. What about settlement? Yes, less lawyers love to fight and contest and litigate every single matter, but would settlement be a way or an option to save money? Because don't forget, the parties have to do cost submissions. Again, you have your Harvey Specter cost, because Harvey Specter must also look at your cost submission and review the cost submissions. So there's another set of legal fees that have to be spent on cost submissions. Maybe I want to check with Krista first on her view. Getting the parties, so as a tribunal, getting the parties to try and agree on a quantum of cost so that the tribunal does not need to consider and go into every single item. As Raja started earlier, it's always good As a tribunal, if you can concede on your matters, that's the best. We don't need to fight. No need to spend hours and hours looking at hourly rate. Is that a good idea, Crystal?
It's definitely a brilliant idea, but then the thing is like whether it's possible to get parties to agree on that, it's a big question mark. Two parts of the cost that we talk about, right? Legal costs and also the rest ancillary. I wouldn't call it ancillary in terms of amount, but then the arbitration costs itself. So if you're talking about AIAC costs, you're talking about tribunal fees, transcript, venues and all, figures as figures, no issue whatsoever. But when you talk about the actual legal costs, expert costs and all, it's not close to impossible for parties to agree on the sum, whether it's your figure is more reasonable than mine, or can we agree on reach consensus as to that. My only experience where it's possible for parties to agree is a Section 35 correction to the award. The time parties spend to compute certain issues, and for that instance, it's actually unplanned outage rate, back to PPA again. So in that instance, the time spent to compute the figure, it's actually reasonable in the sense that so the client rep time is being factored in, and the other side basically agreed as to the amount spent to quantify the figures as requested by the tribunal. So the tribunal basically asked the parties, please go ahead, come up with the figures, agree on the time spent for this exercise, and advise me as to the cost spent for this matter. So in that, for that particular instance, it's very successfully done. And it's akin to a consent award situation because you agree on the rates, the limits itself, meaning the fees payable, and then you agree on the cost spent for that matter, interest. So the last part of the arbitration resulted in a consent award, with the partial award being rendered first, directing parties to come to this point. So in that manner, I feel like it's very useful. But if you're talking about cost submission as overall, before you come to the reply cost submissions, I think that's quite hard to actually execute it perfectly. Yeah.
So I had one experience, this is also quite interesting. So the tribunal invite the parties to agree on the quantum, and they give various scenarios. So you have claim, you have counterclaim. But of course, if you're thinking, hey, if I'm winning, of course, I want to put the highest figure. And if I'm losing, I want the lowest figure. Then that's normally what we argue when we're in court. So then you have to hypothetically decide that if the claim is allowed, counterclaim dismissed, what happened? Is there cost? Is there no order as to cost? And in that case, the parties actually agreed on a lump sum amount depending on circumstances. So you give all four scenarios, whether you win half, you lose half, or you win all, you lose all in that sense. So I thought that's actually quite interesting because then you don't even need to go on and argue. But in reality, I think that might be challenging because a lot also depend on the facts of the case and how it works. Raja, what's your experience on this?
All this generally depends on whether or not you have someone like Crystal or Sarah on the other side, and they're more open or amenable to these kinds of things, because at which point common sense sort of prevails over your client's necessary interest and angst. And so in those situations, I think, although in practice you may find it rare, but in those rare occasions, I think it's possible. Otherwise, or in domestic arbitrations, I think that's more possible. But international arbitrations, I think unless familiar with the counsel on the other side, they know you, they are aware of the manner in which you practice, then I think in those circumstances. But otherwise, I think really it's everyone for themselves as far as cost is concerned.
Sarah, what's your experience over in that jurisdiction? It seems like perhaps the European might be more open and liberal when it comes to settlement discussion.
I don't know. I mean, the issue with, well, there's two things. I think the issue with settlement discussions is very often they're made without prejudice and they're confidential. So parties are a bit wary to bring them to the attention of the tribunal. Generally speaking, to your point about whether or not tribunals can get the parties to agree on their cost, I personally haven't been in a situation where the tribunal was able to sort of circumvent the cost allocation. what I have seen is tribunals sort of, and this very often happens in arbitration actually, tribunals give the parties an indication that they have very little appetite for an intense debate on reasonableness of legal cost. And this can be done in a number of ways. It can be done through a letter to the parties, throughout a procedural conference. And so you sort of get a hint as counsel that maybe it's not worthwhile to argue on every little bill that you see coming from the other parties, and that sort of guides you as you prepare your submissions. And I think it's a helpful indication that there might be arguments not worth running, or that it would be in everyone's interest if you're able to reach an agreement with the other parties, that it might, you might not have a big debate on reasonableness of the cost, that you might just concede, that each party will concede that the other side's costs are reasonable. And equally, I have seen many instances in which the parties agree that they will not be seeking all of the underlying documents to substantiate the cost, so that the tribunal is presented, for instance, with a list of the legal cost without the underlying invoices, and the parties have agreed that they will take these documents on face value. So, that's to make the cost submissions a bit more streamlined and easier, and the tribunal isn't bombarded with issues with invoices from hotels and legal fees. That I have seen, but it's more on the practical aspects. I've not seen a tribunal that was able to get the parties to agree on the quantum of costs.
Thanks. The AIAC clock is ticking, and it seems like I have 3 minutes to wrap up to release everyone to this welcoming reception. Just before I end the session, I want to take this opportunity to ask the panelists. Perhaps I'll start with Raja, Krisa, and then Sarah. Just give one sentence. What is your key takeaway on this topic?
What happened to ladies first, right? But yeah, I'll give it a shot. In terms of cost, I think we hopefully we've managed to give you a few tips as to what are the best practices in terms of allocation of costs. I think from what you've heard earlier, it's quite clear that there's no hard and fast rule. Unfortunately, there's no standardized version across jurisdictions. It really very much depends on the circumstances of the case, really very much depends on the nature of the case as well. And hope to God you get some Harvey Specter type lawyers. Yeah.
Okay. For the issue for me is that this 1 hour sessions will not be able to cover a lot of topics. So what I choose to share with you is that there are other areas or topics that perhaps you need to look into to hone either your skills or knowledge, or improve your knowledge in terms of this topic that we talk about. First thing is, for Malaysia, don't look into contingency fees, look into conditional fee arrangement. Okay. For managing your cash flow in terms of arbitration, look into separate advance deposit, whether that's something that's favorable for your clients, especially if your counterclaims is, or the other side counterclaims is huge. And try your best to learn a little bit more about third-party funding. It's getting hot topic, and chances are it will come to Malaysia very soon. And finally, an issue that we'll touch on briefly, but we didn't really have time to go into, quarter bank offer. I've used it last year twice, and it's been really successful, especially if the amount dispute is not huge. So you're talking about between 5 to 10 million. Parties usually come to sense about the cost of arbitration and whether a sensible, commercially acceptable offer should be given, and times of actually doing it with your firm. So we managed to resolve the matter by exchanging 2 to 3 times quarter bank offer to each other. And that's my note.
Sarah?
I'm very much aware that I am keeping you from going to the opening cocktail, so I'll be very brief and hopefully leave you with a phrase that is as catchy as the winner takes it all introduction. And that is, when it comes to cost submissions, I think you have to aim to be good and be gone. And what I mean by that is, bear in mind that you're coming usually to cost submissions at the end of long proceedings. And so you have to be pragmatic in how you approach the cost submissions, only raise arguments that will be relevant to the determination the tribunal has to make. who won the issue? Was there procedural conduct that impeded the arbitration from going forward in a cost-effective and expeditious manner? And leave everything else and legal battles of that person didn't respond to my email on time, leave them out. That would be my piece of advice.
So for me, I will end by saying it to the junior lawyers or students soon to be practitioners. Don't forget your course submissions. Don't do it last minute because it's also very important. A lot of time we focus on substantive and suddenly feel that I only need 1 day for course submissions. Don't do that, okay? Thank you. With that, I end the session.
Thank you to our moderator and speakers for the enriching session. Please remain on stage with us. I would now like to invite Dato' Sundararaju on stage to present the panel with a token of appreciation. Thank you, Dato'. Thank you all. As we reach the end of this year's AIAC YPG conference, I would like to invite our AIAC YPG co-chair, Ms. Jasmine Sapienza, on stage to deliver her closing remarks. Jasmine, the floor is yours.
Thank you, Sanjay. Thank all of you who made the effort to come here, especially you, those of you joining from overseas. We're so happy to be hosting you here at the AIAC in the event as a prelude to the AIAC APAC pre-moot. Law competitions such as the moots are a wonderful opportunity to gain perspective for future career as a young lawyer and to enrich your knowledge for a career in arbitration and to build a community in arbitration. In terms of your future as young lawyers, we advise that you explore alternative careers in law and arbitration. You will all have the opportunity to meet professionals from so many walks of life, different cultures, different nationalities. Take advantage of that and explore non-traditional legal career options such as legal tech, legal consulting, or even entrepreneurship that young lawyers can pursue in addition or in parallel to their traditional law firm roles. It's a wonderful opportunity to grow our soft skills, since moot opportunities highlight the importance of developing soft skills such as communication, active listening, emotional intelligence, and the adaptability to pivot and thrive in a rapidly changing legal landscape. Let's take this opportunity to further a potential career in arbitration. Take a look at diverse practice areas even within arbitration. Witness how arbitration often provides opportunities to work in a wide range of cases, from corporate arbitration to construction arbitration to art arbitration. It's important to take advantage of these events to become familiar with the growing demand for skillful and resourceful practitioners. As Kaijun said before, the increasing complexity of legal disputes and the global nature of business have led to the rising demand for skilled arbitration professionals in various industries. Moots are also a wonderful opportunity to develop a community in our profession. It's so important to build a professional support network to take advantage of being exposed to different groups of people through the moots. The world of arbitration is primed for building relationships with peers, mentors, and colleagues to seek advice, share experiences, and collaborate on projects within the legal community. These words ring particularly true to what Dato' Nitin was mentioning in his keynote speech, some words that I can adapt to my own experience. First, having heard of the AIAC in the Bismuth 2017 edition, where I participated representing my university. And I'm happy to now be part of the legal services team as a senior international case counsel and to be talking to you as AIAC YPG co-chair. In return to all these opportunities that the moods and competitions can give to us, it is further to building meaningful connections. You will stay in the know about conferences, seminars, and workshops to stay updated on industry trends, expand your knowledge base, and connect with other professionals in the field. Lastly, please remember that you can always give back to the community by joining young practitioner groups such as the AIAC YPG. I take advantage of this opportunity to invite you all to become members of the AIAC YPG by signing up on our website. This is a platform to help foster and further your connections in the field of arbitration. Lastly, thank you to Dato Nitin and to all the panelists who joined us today. Thank you for 2 wonderful sessions. And with that, I leave you to enjoy the team briefing and social events. Please feel free to approach me or my co-chair Kai Jun if you have any questions about YPG. Best luck in the competition, and thank you so much for being here.
Ladies and gentlemen, we are deeply honored to have been part of this extraordinary gathering, surrounded by brilliant minds and passionate souls dedicated to advancing the field of ADR. As we bid farewell to this year's AIAC YPG conference, let us carry forth the knowledge, connections, and inspirations gained here into our respective endeavors. Let us continue to push boundaries, foster collaborations, and champion excellence in the field of alternative dispute resolution. On behalf of the AIAC YPG Council, I extend my warmest wishes for continued success and fulfillment in your professional and personal pursuits. Until we meet again, stay inspired, stay connected, and keep striving for greatness. Thank you and good evening. We will now be having our team's briefing here at the auditorium, I believe, which was, is Dr. Ajar here? Yes, so Dr. Ajar will be conducting the team's briefing. So you can see here, for the arbitrators, we'll be having the arbitrators briefing in seminar room 1, which is in the annex building. So you can make your way there. Ajar, floor is yours.
All right, good evening. Thank you, Sanjeev. Thank you, Datuk Sundra Raju, for being here and being part of this team's briefing as well. First of all, just to clear things up, I'm not here to talk about cost allocation or anything very serious. So you can all relax. You're here. First of all, thank you very much for coming. All right. Brian has just reminded me that the arbitrators don't need to be here. They need to go to the arbitrators briefing room, which is on the basement floor, lower ground floor, and across to the other side. Yes, so if any arbitrators are here, would you please move to the arbitrators briefing? Thank you. Yeah. It's fine. Yes, all right. Now that have moved people where they should be. Again, my sincere thanks for everybody to come here, fly down all the way. When we started what is now known as the AIAC APAC pre-moot, a lot of people had told us that teams would not actually fly down to Kuala Lumpur after having done the rounds online. So first and foremost, thank you for coming down and proving them wrong. Yes, it's a pleasure to be here. It's a pleasure to interact with all of you. And those you've made it so far, you know you beat over 150 teams, which may just be larger than the West East. Yes. So if you're here in the eliminations, you're already winning. Let's hope something in Hong Kong or Vienna. Right? Let's start with the housekeeping rules. Where do you have to go? What do you have to do? It's each of you will get this card, which has a small QR code here. Yes, all you have to do is scan it. It will tell you where the rooms are, what needs to be done, who are you pleading against, and as is always the case with people coming from outside, we all love the Wi-Fi. Yes, please connect to AIAC guest. You don't need any login. Just give your consent and you're good to go. All right. We've tried not to print things out in order to make things more green and sustainable. That's why the QR code. In case you face any problems, you will see all of us hovering around like bees. You can just catch any one of us and ask us whatever you want to ask. Otherwise, the reception desk is the default rule. Yes. We have a lot of social events along with all the serious stuff, which will also be there on the QR code. So in case you're interested in all those networking dinners and social events, if you're not interested, there are free drinks. I think that should make you interested. Yes. There are also awards, some of which pertain to the general rounds. Many people who are not here to receive them. But a lot of awards are also for the elimination rounds per se, especially cash ones. So you might be able to reimburse your entire travel if you've had proper drinks. Yes, that is. We've tried our level best to make this moot as inclusive as possible, which has always been the agenda when the APAC was started, the Asia Pacific pre-moot. And because some teams could not travel due to various reasons, some visa related, some finance related, some schedule clashes, what we have done is organize a special pre-elimination round which is why some of you will see that your schedules don't show who you're going up against, right? So those rounds will also take place at 9 a.m. in order to give those 8 teams a chance, 1 second bite at the forbidden apple, if they can still make it to the elimination rounds. And that is why in the 12 p.m. rounds, it is those teams that go through who will then be competing. All right. So those teams are those who were very, very close to the cutoff. And hence, in all fairness, we thought they deserve a chance to get a second shot, right? Which is why the 9 a.m. rounds, you need to be there 30 minutes in advance. Yes, you need to confirm with the reception that you're there. You'll obviously have your hearing rooms. If anyone is missing, not showing up, please let us know. Standard house rules. Once you're in the room, please talk to the bailiff, tell them who you are, which university you represent, what are the speaker names. I don't know if you're following the entire WISP protocol and you already have your name tags and name badges to put on the desk. Otherwise, please inform the bailiff so that there's no confusion on who's speaking for who. All right. Any questions so far? Pretty standard, right? Your coaches would have drilled all this into you by now. All right. Every time you decide to put yourself up to the axe for the elimination, you have to come to this very stage to get axed, right? So this is where the announcements will be. Here, after the rounds, as soon as the rounds are over, please leave the room. There is no feedback, so please don't ask arbitrators for feedbacks. There is no feedback in eliminations. I know some coaches are going to frown on this, right? But rules are rules. So you'll be here, and here is where we'll tell you if you progress to the next round or not. All right. Please note all time zones are Malaysian. reset your clocks. Thankfully, there's no daylight saving. Yes, when you land up in Vienna, you also have those problems. Any questions? None? All right. Please be careful. And I insist and emphasize and reiterate at the same time, please be careful about scouting. For those of you who do not understand scouting, I know most of you do. If you are scheduled to meet the other team in Vienna or in Hong Kong, it may not be this team, but if the university that you represent is scheduled to meet them in Vienna or Hong Kong, you cannot watch their rounds. If you do, you will be disqualified. Not only here, but even in Vienna and Hong Kong. So all these months of hard work would just go down the drain. You would think that nobody is that stupid, but you would be surprised by what people can come up with. Yes, a lot of times it happens by accident, so we don't blame teams, but the consequences will not change even if it is by accident. So the recommendation is be extremely, extremely careful when you walk into a round which A, is conflicted for your university, and B, you're sure you're not scouting. The other thing is that only 5 team members are allowed in each round to be there along with the speakers. I don't know if any team has more than that, but if you do, then you may have to take turns. All right. Any team has more than 5? Raise your hand now. All right, one team. All right, we'll see. How many are you? 8. All right, we'll see if we can fit you in. Otherwise, you'll have to bear with us. All right. Before you begin, please check with the tribunal if they are ready to begin. All right. Sometimes in your, how do I say, enthusiasm to present the case, you don't land up waiting for the arbitrators. Please remember these are elimination rounds. So the questions would be more. They would be a little more difficult. But then that's the idea. Because if you were to go to Vienna or Hong Kong, it would be the same. As much as these are practice rounds, they are also intended to give you the real deal of what you would face there. So the general level of arbitrators would be more senior. Their questions would obviously be more, how do I put, have more depth, right? And sometimes they'll push you to the test. All right. Any other questions? No electronic equipments. Please switch off your mobile phones. Put them in airplane mode. If you want AI to help you, please don't try it. You've read the rules. Yes. No WhatsApping. Don't send WhatsApps to each other, especially the coaches and other team members. People who wear digital watches, everything can be seen. All right. So please don't try to do these things which make an embarrassing situation for you and for us. Okay. If you, as per the rules, you're not allowed to record these sessions. Some coaches insist on recording. I don't think that's permissible. If you want to record, you will have to inform the arbitrators who will then check with the committee, and only upon the consent of both are you permitted to record. So please do not pull out your mobile phone and record the session. All right. Okay. If you don't show up within, we'll wait at max for a minute, 10 minutes of the scheduled hearing. In extreme cases, for justified reasons, another 5 minutes maybe. But after that, it's an ex parte hearing at your cost and consequences. Yes. So it's advisable that you're there 30 minutes before the round and not last minute. Okay. The finals will be here in the auditorium, which is for everybody to see. And we strongly encourage that everybody joins us, because if 2 top teams out of 150 odd teams are going to be speaking, Well, you might just have a lot to learn. All right. Any questions? Concerns? Where do I go? What do I do? In the QR code, you'll also find guidance about what to do in Malaysia, several FAQs that are generally asked. Yes, we have networking dinners. Again, most of your rounds will be followed by coffee, tea, which was served in the AIAC itself. Any other major concerns? All right, yes, Brian says the QR code will be active tonight. Yes, the lady at the back. Sorry? Okay. Okay, that's a good question. So usually if you're doing that, you take permission from the arbitral tribunal and you keep the phone in a manner that it can be seen. Yes, because if your messages are coming in, usually the arbitrators would notice. Otherwise, you can ask the bailiff to help you. Right? The bailiff can always tap when you have a minute left or something. And that's an agreement you can reach with the bailiff as well. Usually arbitrators, a lot of good arbitrators would keep time for you and in general give you an indication that your time is about to end, right? Otherwise, stopwatches, the safest bet. Yes, but in all these matters, please remember, as in a real arbitration, it's the tribunal that is supreme. So if the tribunal in its judgment believes, and I say believes in good faith that you will not violate the rules, they may permit it. But if another team raises an objection or otherwise, then, we'll have to follow the entire drill. Yes. And I don't think anybody would want to be there. Yes. Any other questions? None at all. You want to discuss the problem? Yes? No? Tired? 6 months are enough? Now you just want to get done with it? All right. Brian, anything else you want me to cover?
No. So thank you, everyone. We'll proceed to the networking event. So I encourage all of you to come for that. You have to go to the lower ground level, LG, and then walk across to the car park. We'll have some ushers there to guide you. It's just above the car park. All right. So please, everyone, join us there for the networking event.
All right. Wish you all the very best for now and for Hong Kong and Vienna. All right. Good luck. Thank you again for being here.